somewhere. So.
Do they know?
Oh, you are live, David. Don't give the court instruction.
So, well, anyway, and they're thinking of this stuff anyway. Right. But I'm just saying that we can't sit at home and let this happen. And we have to do something that gains attention. And we've been to the governor, we've been to our legislators, we have been everywhere. Representative Carpenter is on our side. Somebody told me that he was on Michael Gooch's show, I think this morning or yesterday morning, and just talked about the grand jury, how important it is, how we're, we have support. We need to just do whatever we can do to force the issue. And the media people that I talked to said, they said at first glance, this is sort of complex, but they said if it's going on and you do a sit-in, they said that will surely help force the issue. And that's where we're at. If we just sit here, it will just keep going on year after year.
So you're sitting in the courtroom, is that where you're going to be?
Well, or try to get in the courthouse. I actually think that they're already questioning people about what your business is. I don't think they'll actually let us go in there. I mean, I guess if you said I'm getting a divorce and I need divorce papers, but I'm not going to lie to them. I'm just going to walk in there and I'm going to say, I'm here to enforce the constitutional rights of grand juries to investigate. Let me in the door. Grand jury's inside here somewhere. I'm going to find it, and they'll probably turn me away. But
and is that not unconstitutional for them to turn you away?
It is. Yes.
Yes, it is.
Then you need to get it right. I'm sorry, sir. You're going to find this piece of paper saying you're telling me I can't come in here.
Yeah.
Well, and when I say it's unconstitutional, the Alaska Supreme Court says no citizen has a right to approach the grand jury directly. You have to give your concerns to the district attorney. But
that's against our constitution.
But what the people who wrote our constitution, if you want the intent, see, they wrote the power of grand juries to investigate, make recommendations concerning the public welfare or safety shall never be suspended. But the delegates on the record said this: the grand jury can be appealed to directly, which is an invaluable right to the citizen.
Yeah.
Well, so do they get to keep you outside from the grand jury and say, oh, go talk to the district attorney, and if he thinks he should be investigated, he'll inform them, but if he should be investigated, he won't inform them. And that's we have that in writing that they won't.
Right.
So we either step up to the plate now and fix it now, or we let it go and hope our kids 50 years later, after it's all set in stone, can do it. I'm not going to wait. I got 2 beautiful daughters and I'm going to nip this in the bud right now.
Right.
Yeah.
Straight well.
Yeah. So anyway, that's basically my.
But I want to know, and I know you had some ideas too, about what to do if we're approached in the courthouse or even on the sidewalk. When you said don't say anything.
Oh, yeah, you don't have to answer any questions. Don't answer any questions.
Yeah.
Like, hi, I'm asking you a question, and your answer is, I don't answer questions. Also, make them care to you. Like I was telling them last time, that Canadian pastor whose name escapes me.
I never am.
Told the cops, nope, do it Nazi style. Made him carry.
Yeah. Well, and like I said, I've been arrested. I've been more than that. It's fairly traumatic. I don't think, but the way I look at it is on my deathbed. I'm going to look back at this point in my life and know that I did my best to protect my daughters and the rest of the community. And was I too chicken to kind of force this issue and let them get away with it?
Yeah.
And well, you guys might have some idea how angry I am. So be cautious following me because I'm, so. But again, this issue is gaining traction. It is. I went to Fairbanks. There were Fairbanks Borough Assembly members contacted me, said, give us your draft resolution. We're going to start moving forward in Fairbanks. A TV station up there came into one of my things, actually set up filmed the whole thing, interviewed me.
Sweet.
And I don't know if they're gonna publish, they didn't air it that night, they said they're gonna, but it is starting to become more mainstream and more.
Yeah.
More, it's getting to the point where the media is starting to warm up to it. And so, and the last thing we want to do is do anything that will take away from the momentum we built. Like,
Right.
no violence, no saying anything, just total respectful, whatever, and no fighting. Like I said, we need to just say, we're here to enforce the Constitution, and that's what we're going to do. And we have a right to petition the government and to peaceably assemble. We're here peacefully. So, yeah.
Another possibility, and I've been thinking about this. And I mentioned it last week, I think, was if they ask you, what are you doing here, or what you think you're doing here, or why should you be here, or whatever, is it possible to say something in answering them peacefully, calmly? I'm here to do business with the state. I'm here to do business with the court. I'm doing my
I'm
business.
exercising my constitutional right to
I mean, when you don't answer, that's like, it's gonna push a button, and I hate not answering, at least
Yeah. What,
something that is monotone level. You can't take me to court over it or whatever. It's like, I'm about my business with the state. Is that something wrong? Or-
well, the way
So how
because the
should I
grand
do it?
juries are there, I had thought about to try to get in. I'm here to talk to the grand jury and to enforce their right to hear from me and to investigate. And if they let us in to talk to the grand jury, first thing I would tell them, like all these things, will you please investigate the Alaska Supreme Court trying to take away your constitutional right to investigate?
Yeah.
I mean, and so I'm not going to lie to the court. They're going to know that when I'm there. I refuse, because lying it starts the little bitty path where you end up in the weeds.
Yeah, no longer.
Just say we're here to enforce the constitutional right of our grand juries to investigate, and of our right to approach the grand jury directly. And see, that gives you the key to go in there, because Wednesdays in the grand jury, you have a constitutional right to go into that courthouse and go right up to the grand jury. That is your reason for trying to get in the courthouse. I'm here to exercise my constitutional right to enter the courthouse and approach the grand jury directly, just like the delegate said, the grand jury can be appealed to directly.
Do we need to have paperwork to present to the grand jury so that they have something concrete to look at? Like what we would like them to investigate?
This flyer kind of has that. See, there's already a grand jury that's investigating, probably not the one that's going to be there Wednesday.
Right.
But yeah, we're trying to not make it too complex either. I mean, we're printing this out, and it kind of goes over what the Supreme Court did, what they did, and then what our Constitution says and what the delegate said, and how they what they've been doing is trying to hide kind of in the scene between what, where the Constitution actually says the power of grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended. That's fairly vague. People are like, well, what does that mean? But see, then the delegate said this. The commentary to that says the grand jury is preserved for all purposes, particularly for investigation of public officials.
Right.
Well, that's a whole lot. That's well, wow. If there's a judge that we have concerns about, and then, well, how do you notify the grand jury that? Well, then later on, the delegate said the grand jury can be appealed to directly, which is an invaluable right to the citizen.
David. Hey,
everybody.
sorry. I don't want to. If you want to, hi, Mr. Ingell, Mr. Haig. We've been live on Facebook. If you want to wrap it up real fast, and then we're going to get started with Mr. Ingell.
Okay. Well, I think I basically wrapped it up. We just want to have as many people as possible show up, because media is now interested. We can't do anything that will damage our credibility, but we have to be aggressive enough that it makes a scene and it gets noticed. So that,
a simple presence, right?
Yep.
A peaceful presence.
Exactly.
Always.
Right. So I'll just wrap up. That was David Haig at our local AFCR meeting. And we just want to encourage everyone to go to the Alaska Grand Juror Association.org and you can be updated there. Of course, you could go to AFCR1776.com and there's updates there. And then the March 15th sit-in is what we were just discussing at 8 a.m. That is early, but it's for a purpose. It's that the grand jury, that's about when they arrive. So we want to just have a show of support for them and their efforts. So with that, we'll just move right on. David Ingell is back this week with us, and we are continuing on in his book. I believe we're on chapter 12. Am I right?
13.
13. I'm sorry.
Lucky 13.
I'm behind. Chapter 13. I was sick that week. So anyway, and I will post a link to that under this video on Facebook. And I'm going to go ahead and mute myself. And if everybody else that's online, just be sure that you're muted. And then David will take questions later. Thank you.
All right. Thanks, Chandra. Good evening, everybody. I got back into Alaska Sunday night, so it's good to be on the same time zone with y'all, and it's good to be back. We had quite a storm here yesterday, but it's what toughens us up, I guess. Anyway, so last week or 2 weeks ago, we didn't meet last week because I was traveling. I actually went through that snow dump on last Thursday. I drove through Portland when they got a foot of snow, and that was a mess. I was lucky to get through there. But anyway, back in action now. So 2 weeks ago, we were on chapter 12, and we were talking about how the Supreme Court, they enacted Supreme Court Order 938, which led to Criminal Rule 6.1, which stifled grand jury reports. So today, and when I did my book, when I was researching my book, I tried to find subsequent investigative reports by grand juries, and I couldn't find any. In fact, I was talking to somebody tonight who told me that they had requested a grand jury back in the late 80s or early 90s, and it had to do with somebody who was wrongfully convicted, and the grand jury investigated and ended up releasing, recommending that the person get released. And a couple things that were interesting about my conversation tonight was this was in the late 80s and early 90s, and there were no grand jury handbooks that were handed out to the grand jurors. And this individual brought in grand jury handbooks for the grand jury to read. And once they realized what their rights were, they actually told the prosecutor to leave the room. And they had a strong grand jury foreman, apparently. So I'm hoping to get my hands on that report. I did contact a couple of people with the Alaska court system when I wrote this book. I wanted to see if there was more current grand jury investigative reports, and the archive library here in Juneau, where they had a copy of the Sheffield grand jury documents. I mean, it takes up almost a complete library shelf, a row. They suggested that I contact somebody. They gave me a name and a number of somebody with the Alaska court system, and I tried to get a hold of that person, but they didn't respond, and I actually got a response from Nancy Mead, who is the general counsel of the Alaska court system. And I was thinking to myself, why is she responding to me? But anyway, I was told that they don't maintain a database of grand jury reports, which they should, because if the grand jury is making public recommendations to the public about the general welfare, those are reports that should be available to everybody to review. So just by coincidence, today, chapter 13 is about grand jury handbooks. So in chapter 13, I basically look at three sources. The first one is the 1962 Grand Jury Handbook. And that is attached as an exhibit to my book. I think it's Appendix A or Appendix B. I have a copy of that. I found that on the internet. And I think some of you may have had that. I think David Haig may have had that. So chapter 13 takes a look at the 1962 handbook, and then it takes a look at the 2019 version of the Grand Jury Handbook. When I was writing my book, the most current edition out was the 2019 Grand Jury Handbook. And so there's, as we're going to see in this chapter, there's a lot of differences, in that 37 years, or well, I guess it'd be almost 60 years that passed. There's quite a bit of changes that the Alaska court system made to the Grand Jurors Handbook. And then the last thing we're going to look at is we're going to revert back to Lord Somers. Chapter 1 of my book was about the security of Englishmen's rights by Lord Somers, who was the Lord Chancellor in England back in the late 1600s. And so I want to compare what the Alaska court system is telling grand jurors today, relate it back to what Lord Somers talked about in his recognized treatise about the grand jury and how how things have changed. So anyway, starting the first page, 103 of my book. In the first paragraph, I make the point that, so we've seen in the last couple chapters how the Alaska Judicial Council and then the Supreme Court assaulted the Alaska grand jury through controversial Rule 6.1 and then the Supreme Court decision in the O'Leary case. But I think maybe more impactful has been the lack of the court system to properly educate Alaska citizens about their duties and powers under the common law. And if you'll skip down a couple paragraphs, I cite back to this Mr. Buchwald. He was the author that we looked at in the previous chapter, where he wrote a book about grand juries and the need for more grand jury investigations. And he noted the significant negative impact that occurs when citizens serving on grand juries are not properly educated by government officials. And I want to read this quote in its entirety. He goes, "Presumably, grand juries stopped investigating on their own and writing reports because they did not know they had this common law power. It was never abolished by federal statute, but today grand jurors remain ignorant of their power and limit their role to considering charges put forward by the federal prosecutor. In fact, the standard charge judges give to a new federal grand jury does not advise them of their power to investigate and issue reports. Furthermore, there is no explanation of this reporting power in the handbook for federal grand jurors. which grand jurors receive during orientation to acquaint themselves with their duties and responsibilities. So I'll stop right there. So, well, let me just read the last sentence. Instead, there is the following statement in the handbook that would dissuade a grand jury from investigating anything without the federal prosecutor's blessing. So I think this quote is very important because it shows a consistent parallel between what is happening in federal courts and what's happening in Alaska. And remember, the Alaska grand jury has more powers than the federal grand jury does. But you see here where, as we've seen throughout the book, government officials don't like grand juries because they can call them out on what they're doing. So in the federal court system, lo and behold, there's a handbook for federal grand jurors, and it downplays the investigative powers of the grand jury. And so what we're going to see here in a moment is that back in 1962, the Alaska court system elevated the role of the grand juries in keeping government officials honest and investigating matters. But today, 60 years later, the court system has undertaken a role of trying to dumb down grand juries, to not educate them. I mean, what I heard today, that in the late 80s, that the grand jury handbook was not being passed out to grand juries. Well, that's right after the Sheffield investigation. That's right around the time of the Bartlett sex scandal. And so maybe by then, maybe back then they hadn't had a chance to revise the handbook that was in place in the mid 80s. I'd be real curious to see that edition and see what it said, because they weren't handing it out. They didn't want grand jurors to know the power that they had. So, and this is what we're doing here, right? I mean, we're educating, we're all getting educated about grand juries so that we understand the powers and the duties that we have. So going over to the next page, 104. So at the start of the second paragraph, I talk in my first sentence there, the 1962 handbook informed grand jurors of the important role they played in keeping the government in check. So that was something that was in the handbook. It's like, you need grand jurors, you need to help keep the government in check. Going down to the next paragraph. The 1962 handbook left little doubt that the grand jurors were an independent body in complete charge of the proceedings. And you see this in the wording. The printed guidelines were suggestive. It's what the grand jury should do, not what it must do or shall do. So again, it's up to the grand jury what they do. The courts and the prosecutors are only there to suggest what they can do or what they should do. The grand jury makes the decision there. And so what we're going to see is how that changes, in the 2019 version. But continuing on with that, the next sentence, the district attorney was not only an advisor, but the 1962 handbook warned that even the best of advisors are sometimes in error. That's a very important admission that is nowhere to be found in the 2019 version. The court doesn't want you to think that prosecutors are in error, but we all know that they are. And so here was an explicit admission in the grand jury handbook reminding people that, just because that guy is there in front of you or girl in a suit and a tie, that doesn't mean that you got to, believe everything that they say. Sometimes they're in error. Sometimes, they're honest and they're in error. Then you run into the problem when they're not honest. And as we saw in chapter 8, when we talked about the founders and how they viewed prosecutors, you know, they weren't very kind in their assessment of prosecutors. So anyway, to me, it was, you know, pretty noteworthy that back in 1962, the handbook had this explicit warning that, hey, you know, they're just an advisor and sometimes they're wrong. So going on to the next paragraph, I actually, uh-oh, went too far here. Hold on a second. Yeah. Okay, here we go. So turning to the next page, let's see here. I'm sorry, my mouse skipped ahead here. Okay, so down to the next paragraph. I go, the following excerpts from the 1962 handbook highlight the grand jury's independence. First one, and these are direct quotes from the handbook. In time of peace, no citizen can perform a higher duty than that of grand jury service. No body of citizens exercises public functions more vital to the administration of law and order. So, you know, right there, it's the Alaska court system is acknowledging how important the grand jury is. The next item, the importance of its powers is emphasized by the fact that it is an independent body answerable to no one except the court itself. So right there, the grand jury is not answerable to prosecutors. How can a prosecutor tell it what to do? Right there. I mean, it's in black and white. And I would even, you know, when they say it's not answerable to anyone except the court itself, I wouldn't go that far. Have very, you know, if you look at the common law that we have studied, even the courts have very little jurisdiction over grand juries. And we saw that in Judge 1985 report recommending the impeachment of the governor. Judge McGee said, hey, you know, it doesn't matter that whether I disagree with this report or not is irrelevant. It's not for me to decide. The only thing that the only thing that the court can decide is whether this investigation is within the scope of its powers under the Constitution. And as we've seen, that's basically unlimited. You know, anything that affects the general welfare is pretty broad. So I just wanted to point that out. Then the next paragraph, not only in theory, but in actual historical fact, the importance of the grand jury has been demonstrated. This power of the grand jury to protect the citizens from the despotic abuse of power has been repeatedly exerted, not only in England, but in this country, even before the Declaration of Independence. Now, there are so many loaded themes and concepts in what I just read. I mean, this statement gives credence to everything that we've learned about the powers of the grand jury under common law. I mean, they're talking about England. They're talking about this country before the Declaration of Independence. This is the Alaska court system in 1962, referring back to these common law powers. It was an acknowledgement back in 1962 that, yeah, this is not in theory, but in actual historical fact, that the importance of the grand jury has been demonstrated to protect citizens from the despotic abuse of power. And that's exactly what you all in Kenai have been trying to get through for the last several years, that there's been an abuse of power and you've wanted an investigation, but yet the state has come in and has stopped you from doing that. Several investigations, even not only David Higgs, but Ray Southwells into the OCS. So it's the court system and it's the prosecutors that are abusing the system. And, you know, this is why we're all meeting and talking about this, because we're trying to figure out ways to get around it, to generate the political support that we need to force change. And we can talk about that. I know that's been a recurring theme. I know Waynette has expressed grief a couple times, you know, at how do we force changes. Tuesday, I spent most of the afternoon over in the Capitol building talking with some legislators. There's a couple bills coming out that deal with judicial reform to the extent that we can without a constitutional amendment. We can talk about that maybe next week a little bit. Anyway, I want to keep moving on here. So the next paragraph, and this next paragraph talks about criminal indictments, but I'll pick up with like the second sentence there. But when it has reason to believe that other evidence within reach will explain away the charge, the grand jury should order such evidence be produced, and for that purpose may require the district attorney to issue process for witnesses. So there's another admission from 1962 that, you know, grand juries are in control of the proceeding. And if they think that, you know, there's some evidence or something that they want to look into, it's up to them. They don't have to ask the district attorney for permission. I mean, that's absurd. Going on to the next subparagraph. Charges of crime may be brought to your attention in several ways. Number one, by the court. Okay. Number two, by the district attorney. Number three, from your own personal knowledge or from matters properly brought to your personal attention. Number four, by private citizens heard by the grand jury in formal session with the grand jury's consent. As to matters brought to your attention in classes 3 and 4 above, emanating directly or indirectly from the grand jury itself, it would be wisest to consult with the district attorney or the court in advance of undertaking a formal investigation by the grand jury, although this is not mandatory. So again, the court and the prosecutor are advisors. And yeah, I mean, grand jurors should ask them their opinion on things, consult with them, see what they think. But they don't have to take their answer. If they think there's more to it, they have the ability to go out and investigate things themselves. And one thing to keep in mind with this, what I just wrote, that is most, you know, remember, the grand jury looks at two things. There's criminal indictments, and then there's investigations. So with criminal indictments, it requires a prosecutor to indict somebody. So when you're looking at a criminal indictment, yeah, it makes more sense to consult with the prosecutor in those cases, because the prosecutor is going to be the person, you know, bringing the charges. But when it, you know, compared to a grand jury investigation into matters of public welfare, there, nothing is required from the prosecutor, because the grand jury is going to be investigating and making recommendations. And oftentimes there's going to be a little bit of a conflict, because what if the grand jury wants to investigate something in the state government? Now, you know, maybe the prosecutor has a conflict. So that's something that I just hope that we can all get out and educate grand jurors, that when it comes to investigations, you know, they should not be impeded at all by prosecutors. So on to the next paragraph here from the 1962 handbook. In order that the grand jurors may not be subjected to partisan secret influences, no one has the right to approach an individual member of the grand jury in order to persuade him that a certain indictment should or should not be found. Any such individual should be referred to the district attorney in order that he may be heard by the grand jury as a whole. On the other hand, a citizen is at liberty to apply to the grand jury for permission to appear before it in order to suggest or urge that a certain situation should be investigated by it. So here again, we have that kind of that distinction between a grand jury getting involved in a criminal indictment at the request of a district attorney, or on the other hand, a grand jury investigation. So this last sentence in there, on the other hand, a citizen is at liberty to apply to the grand jury for permission to appear before it in order to suggest or urge that a certain situation should be investigated by it. So, but that's not the case today. And in fact, this rule, you know, as Supreme Court Order 1993 is directly in conflict with this. So let me move on here to the next. This will be the last item, I think, that was in the 1962 handbook that I drew out. It goes, in addition to the duty of the grand jury to hear evidence and decide whether formal criminal charges should be proceeded with, the grand jury has the additional important duty of making investigations, and here's the key, on its own initiative, which it can thereafter report to the court. Thus, a grand jury may investigate how officials are conducting their public trust and make investigations as to the proper conduct of public institutions such as prisons and courts of justice. This gives it the power to inspect such institutions and, if desired, to call before them those in charge of their operations and other persons who can testify in that regard. If, as a result of such investigation, the grand jury finds that an improper condition exists, it may recommend a remedy. I mean, I think this is what David Haig was talking. I think he may have cited part of this when I first tuned in, because it, you know, there's so many powerful things in this statement. It's saying the grand jury has the additional important duty of making investigations on its own initiative. So why today does everything have to go through either the court or the prosecutor? That's wrong. I mean, and keep in mind, what the 1962 handbook is saying is the understanding of the powers of grand juries under common law. So, and this is what we've been studying, you know, for the entire book. So, and then the next sentence, you know, the grand jury may investigate how officials are conducting their public trust. So why can't we have an investigation into Marley Greenstein? Why can't we have an investigation into the Kenai judge? Why can't we have an investigation into the DA? Why can't we have an investigation into the OCS? Why can't we have an investigation into the judges and prosecutors in Juneau? It's the public trust. And so the 1962 handbook made it very clear. And further on, down the next line, it says, investigations as to the proper conduct of public institutions such as prisons and courts of justice. Boom, there it is. Courts, you know, it's just beyond me that these, you know, these judges and prosecutors, they think that they can stop investigations into our courts of law. Because right there, it states how important it is for the public to be able to investigate courtrooms and judges And, if desired, call before them those in charge of their operations. Like one thing I'm going to be recommending in this upcoming legislation, I'd like to see grand juries investigate our courts on an annual or biannual basis. I mean, we used to do it with prisons, right? First 20 years of Alaska, I think we covered that back in chapter 8 or 9. So if the prisons were investigated every year, why not investigate the courts? There should be a grand jury in each of the 4 judicial districts that investigates the courts. They can open it up. They can have people come in who feel that they haven't gotten justice. They can look at the financial records. They can make sure that everything's in order. I heard today that there's somebody up in Fairbanks that has been waiting, that got arrested, has been in jail for 5 years without a trial. That was told to me by someone extreme, very reputable. How can that happen? Who, I mean, that makes my blood boil. How can someone we're guaranteed the right to a speedy trial under the Constitution. How can somebody be sitting in a jail cell for 5 years without a trial? Who's in charge of that? The Alaska court system? Yeah. The prosecutors? Yeah. Just think, if we had an annual grand jury investigation, these kind of things could be brought to, another issue is the right to competent counsel. Another thing I was talking about with somebody today. If you're indigent, if you can't afford a private attorney, good luck getting your public defender or your OPA attorney on the phone. This is a common thing which is happening in our jails. People try to get a hold of their attorneys and they never return phone calls. That's a violation of professional responsibility. It says right in the rules of professional conduct that attorneys are supposed to promptly return phone calls of clients and are supposed to discuss cases with them. They don't do that. Another thing that needs to be investigated, we need to have annual investigations, and this is something that I'm going to be, I think, bringing up in these 2 bills. Is I think there ought to be grand jury judges. I think they ought to be, and the judges would be mostly just for swearing in grand jurors and making sure that there's no bias on the panel, and making sure that they're given the tools to do these investigations properly, which means independent special counsel and money to hire them. So this is something I think I'll be pushing for in the legislation that is in both the Senate and the House right now. So let me, okay, so going down to the next paragraph, now we're done with the quotations from 62. But in this first sentence, everything that I just read you appeared in the first 4 pages of text in the 1962 handbook. It wasn't something that was buried in the end. People start reading stuff when they fall asleep. No, the Alaska court system, the original grand juror handbook had all these important matters up front and center. It wasn't buried in the back like you're going to see here in the 2019 version. Some of this stuff is buried. So let me, let's see, I guess I repeat myself here at the bottom of page 105 again, the last paragraph. The 1962 version portrayed the DEA as an advisor and warned grand jurors that even the best of them will sometimes be in error. Here's something I wanted to point out. On the next page, the first full bullet point down, it says, wait until the district attorney is finished ordinarily before asking questions of a witness. It usually happens that the evidence you are seeking will be brought out. Be independent, but not obstinate. Be absolutely fair. You are acting as a judge. Express your opinion, but don't be dictatorial. Anyway, can't get that word out. Every juror has a right to his own opinion. So the thing, what I wanted to focus on there was where I have it underlined, you are acting as a judge. Grand jurors are the finders of fact. You are the judge. So, and be independent. So these are things that, all grand jurors need to be educated about. I bet you probably 90% of the grand jurors today don't understand these things. So we need to get the word out. Okay, so then how are we doing on time here? Okay, so then I go on to talking about the 2019 edition. So in the first paragraph there, I go, the introduction is silent about the grand jury's critical, important investigative function. It isn't until page 12 that the handbook mentions the grand jury's power to investigate and make recommendations concerning the public welfare or safety. But then it defers further explanation of that power until page 24. So, compare those two. So in the first 4 pages of the 1962 handbook, it's up front and center about, the importance of these, of this investigative power. But in 2019, you don't get an explanation of that until page 24. I mean, how many grand jurors are going to read to page 24? Probably not a lot. So things are really twisted around here, but it gets worse. So in the next paragraph, when the 2019 handbook finally gets around to explaining the grand jury's investigating power, it states, quote, generally, grand jury investigations are initiated by the district attorney. They can also be initiated by the presiding judge or by members of the grand jury. So I write, this language represents a notable departure from the 1962 handbook, which instructed grand jurors that they had the, quote, additional important duty of making investigations on their own initiative. I mean, do you all see the switch there? I mean, in 62, they're saying, you've got this additional important duty on doing this on your own initiative. Then in 2019, they say, well, it's normally going to be initiated by the district attorney and, blah, blah, blah. So again, it's a shift of focus. Then the next paragraph. The 2019 handbook also curtails the important ability of citizens to appeal directly to the grand jury. The 1962 handbook expressly stated, quote, a citizen is at liberty to apply to the grand jury for permission to appear before it in order to suggest or urge that a certain situation should be investigated by it, unquote. The 2019 version makes the prosecutor the gatekeeper for citizen inquiries. And then it says, this is from the 2019 handbook. Prosecutors also sometimes receive letters from the public addressed to the grand jury requesting investigations. In these situations, the prosecutor will probably conduct a preliminary investigation and make a recommendation to the grand jury about whether to take action. So let's just, so big difference, right? In 62, citizen can apply to the grand jury for permission to appear directly before it to investigate something. 2019, well, the prosecutor will probably conduct a preliminary investigation and make a recommendation, So let's just think what's going to be the likely result if a citizen wants the legal system investigated? If that goes before the prosecutor, do you think the prosecutor is going to want the grand jury investigating he or she or their colleagues? Think they're going to want them investigating the judge? Probably not. I mean, here's another thing. Even if it's not an investigation in the judicial system. Let's just look at anything in the state. So state attorneys are programmed to protect the state from liability. You know, it's like this federal complaint, this class action complaint that was filed this summer. It's a 95-page complaint, class action, that was filed in federal court to investigate the OCS. And it wasn't necessarily to investigate the OCS, but the class action points out a lot of places where the state is not following federal requirements. And so what did the state do? What did the Alaska Attorney General do? They're seeking to dismiss the complaint. It's currently pending. It's a 95-page complaint filed this summer, and the Alaska Attorney General is trying to dismiss that complaint. So, you know, the state attorneys protect state employees. It's just that simple. And so they're not going to be welcoming grand jury investigations. I mean, in their eyes, the state can do no wrong. So this is completely backwards. They shouldn't be making, but this is what we're dealing with. This is the reality today, right? With this new Supreme Court order in 1993. In my discussions with Thomas Garber, you know, he got a letter from, I think, the Department of Law a couple weeks ago, and now they've set up a panel of 5 prosecutors to or 5 state attorneys to determine whether his investigation should go forward. I mean, are these going to, you know, I just thought of it. Are these going to be the same attorneys that filed the motion to dismiss the federal lawsuit? I mean, this stuff is just, it's maddening. It's very maddening, as I know most of you feel the same as I do. So let's go over to the next page, page 107. I'll try to wrap this up so we can have some questions. The introduction states, quote, "A grand jury hears evidence only from the prosecutor," unquote. Really? So in 2019, a grand jury can hear evidence. I mean, that just flies in the face of everything, not only the 1962 handbook, but everything that we've learned about common law. Let's go back and think about New York, in San Francisco, in Minneapolis, where we had corrupt prosecutors. So a grand jury can only hear evidence from the prosecutor? There's no way. Moving on, page 7 tells grand jurors, A, they can't conduct any independent research. B, must avoid news reports that might mention criminal activity. And C, must decide the case based solely on the evidence presented in the grand jury room. These purported limitations are way out of bounds when compared to the common law powers outlined by Lord Summers and the historical function of the grand jury. I mean, let's go back and, you know, like back in New York, in San Francisco, Minneapolis, when the grand jurors went out on their own, they split up in 2s and 3s and they did their own investigation. That flies in the face of everything that they're trying to tell you in 2019 that you can't do. But we know better, right? Next paragraph. Such limitations also cut against the clearly expressed concerns of many Constitutional Convention delegates who spoke of their awareness that prosecutors will sometimes omit important evidence. Yeah, we saw that in paragraph 8 or chapter 8 when we talked about the debate on the convention floor. I'll skip that next. I was gonna read the rest of that paragraph, but I'll skip that for now. You know, I go on, I talk about more attempts of the 2019 handbook. I mean, if you're really interested, you know, I think I'm making the point here that there's a big difference between the 1962 and 2019 handbook. So, you know, for those of you who want to, you know, look at more of those, you know, the next page or so, I get into, you know, more of those distinctions. I'll won't go over those tonight. Let's see, going over to the next page, 108. I'll skip over the first paragraph, and then the last page or so of of this chapter is when I go back and I compare what the 2019 handbook is trying to do with what Lord Summers wrote about in his treatise. And I quoted it, I re-quoted it in its entirety because I think it was important. Instead of referring you back to chapter 1, I just thought I would set it out there again, because like halfway down the page, let me see, this would be the third paragraph of Lord Summers' quote. It goes, "Neither may the jury lawfully omit to inquire concerning the parties accused of their quality, reputation, and the manner of their conversation, with many other circumstances, from whence they may be greatly helped to make right inference of the falsehood or truth of the crimes whereof any man shall be accused. The jury ought to be ignorant of nothing whereof they can inquire or be informed, that may in their understandings enable them to make a true presentment or indictment of the matters before them." And I'll read the next sentence. "'Tis certainly inconsistent with their oaths to shut their ears against any lawful man that can tell them anything relating unto a crime in question before them." So just think about those words in relation to the 2019 handbook, where grand jurors have a duty to advise themselves of, for instance, the reputation and the quality of the witnesses. I mean, you think that a prosecutor is going to, let's say somebody has a reputation of falsehoods, of saying lies, and they're accusing somebody of something, and the prosecutor's out to get the accused. You think the prosecutor is going to bring up that evidence to the grand jury that, hey, this person, this witness does not have a good reputation? I mean, I know of cases here in Juneau where the witnesses had a bad reputation, but it was a political witch hunt. Prosecutors brought in these people and they had bad reputation. And then you come to find out that evidence isn't admissible in court during trial. And sometimes judges will keep out that evidence even when it is admissible. So like in the one case I'm thinking of here in Juneau in particular, there had been false accusations made twice in the prior 2 years. And the jury who heard the case, the petite jury at trial, never heard that evidence. But yet to a grand jury, all that evidence is extremely relevant. I mean, grand jurors should be able to evaluate the truth or the veracity of testimony. But according to the 2019 handbook, no, people can only listen to what the prosecutor is laying down before them. It just doesn't work that way. So anyway, turning the page here, again, I highly recommend you to read what Lord Summers had to say, just to refresh your memory of what we studied back in the first chapter, because it's so important. This is what grand jurors are obligated to do, historically and under our system. And it's to discern the truth. You get 12 or 15 people, I think it's 15 grand jurors, and that's a lot of resources. There's going to be people in that grand jury room with you who have been around, have seen things, and that's a wealth of information to draw on. And this is what Lord Summers talked about. He said, there's going to be people in a room, in the grand jury room, that likely have some knowledge of what's happened, and this is what Ray Southwell tried to do. He had some knowledge of some things, and he tried to bring it to the attention of his fellow grand jurors, and he was stopped from doing that by the prosecutor and the judge, which is just wrong. So anyway, I'll open it up for questions.
Go.
Can you hear me? Is David Haig?
Yep. Hey, David.
Hey, thanks for sharing your time and wealth of knowledge with us. I want everybody to listen to this carefully. When we first started going to the grand jury with the evidence against Marla Greenstein, they refused to give my request to the grand jury. We ended up getting over 500 people to sign a petition. 500 people.
Right.
And we went to the district attorney. He said, I'm not giving it to the grand jury. We went to the attorney general. He said, he's not giving it to the grand jury. We went to the presiding judge. He said, he's not giving it to the grand jury. We went to the governor, and the governor's office said they wouldn't give it to the grand jury. So anybody that reads the new 2019 handbook and thinks that your request for an investigation is going to get to the grand jury, think again. It may be in the book, but it don't happen. And so I just wanted to lay that out, that it's far worse than what the handbook says. They're not even following the altered handbook. And I have an email from Assistant Attorney General Paul Myovas, and that email is on the website Alaska State of Corruption, where he admits they will not give that petition, asking for asking for our only judge investigator to be investigated. 500 people asking for it. Nope. Well, that should just scare the hell out of everybody.
Yeah, it does. The whole thing does.
And I had a question here. You had said that the panel that is now screening complaints to go to the grand jury, they're all attorneys. Do you actually know that, or do you know exactly what that panel is, who's on that panel?
Yeah, I don't know. Thomas Garber had forwarded me a letter, and I literally had about 20 seconds to skim it. And because Thomas has got two things going, he appealed when Judge Morris in Anchorage vacated the hearing because of Supreme Court Order 1993. Thomas appealed that order, so he's got that. He's got one thing going there. But the other thing that he did was he goes, okay, I'm going to try to comply with this Supreme Court Order 1993. So he submitted the request for a grand jury investigation into the OCS under, 1993, because he wanted to have parallel tracks going. And I think it was in the last 2 weeks he got a letter, and one of you could contact him, or I don't know if that's confidential or anything. I doubt it is, but I just remember seeing on there that there was a panel of 5 attorneys. I think that they were all Department of Law employees who were screening requests for grand juries, investigations that involved maybe there might have been some qualifier there that it needed to involve either someone of the court, or the investigation was directed towards someone on the court or another prosecutor, and that there was 5. And I have no idea who the 5 are, if they're all from the criminal division or civil division or anything like that. And I take this stuff with a grain of salt because it's all illegal. I mean, they're already doing illegal things. So, for me, I just don't have the bandwidth to focus on more illegal things that they're doing. But it's all illegal, in my opinion.
Yeah, I had seen the letter. It didn't specifically say attorneys, and I didn't know if you had more information. And I just want to point out that, you know, when your book came out, I printed 16 copies and gave them directly to the grand jury. And so, and I gave them the original grand jury handbook along with the new ones. And part of what I asked them to do is to investigate how all this happened and if it was done maliciously to hide. And so that's why I'm so focused on this sit-in, because the grand jury is still in session. And I know, you know, I'm just kind of using this as a platform. This grand jury may very well be investigating everything, including how the grand jury handbooks got subverted. And so you understand how very important it is that we do everything we can to give this grand jury courage, that, you know, the public has their back. And that's the main thing that I'm doing. Is it isn't that I necessarily think will force the Supreme Court to rescind it. We may be able to give the grand jury courage to push ahead in the face of this, you know, Supreme Court order. And so, yeah. And anyway, there was something else I had to say, but it flipped out of my brain, so I'll let somebody else ask some questions.
Well,
David
you know,
Haig, if I'm sorry.
I was just going to say, you know, yes, I agree. The grand jurors in Kenai that are investigating need all the support and education that all of you can give them. David, I think what you did to, you know, hand out a copy of my book to people was very prudent. You know, because there is a copy of the 1962 handbook in there. Now, are they going to read that? Are they going to read 118 pages? You know, I guess I would hope for maybe one or two of those grand jurors to have, you know, read a good amount of that. And hopefully they're driving the bus. The other, you know, there's two things here. Number one, to do the level of investigation that is needed. You know, that's, you know, I requested some of those same things in my grand jury investigation in Juneau, and I knew it was going to take at least a year. So I asked for a special grand jury. The people in Kenai, you know, they may not have the ability to dive into this to the extent that it needs to be. So what I would hope they would do there is that they would recommend that a special grand jury be impaneled to continue, not to begin a new investigation, but to continue their existing investigation. And I hope that, you know, one or two of them are watching this or get a hold of this video, because if you look at it from a legal perspective, you know, Supreme Court order, you know, the state may say, well, you can't do a new grand jury investigation. But if the grand jury says, we want this to be continued, then maybe that's a way around 1993. The other hurdle that they're going to have is in reporting their recommendations. You know, and this gets back to the O'Leary case and Supreme Court Order 938, where now the courts can review the grand jury report and screen out things. So let's say that the grand jury in Kenai decides that some of these people are bad actors and that they ought to be removed. Well, how do we prevent the court from suppressing that report? That's what they did in Anchorage. I mean, there was, you know, they eliminated all the names right before an election in the Bartlett sex scandal. So that's another hurdle that we're going to have to overcome. But I would just, you know, for if any grand jurors are hearing this, I would just say, do your report. I mean, remember that case that we looked at? I think it was in Chapter 5, the Rocky Flats case, where the grand jury investigated. Grand jury, you know, there was nuclear waste that was in the water supply outside, you know, 15 miles northwest of Denver. there was that plutonium facility. Remember that?
Mhm.
And the grand jury was asked to investigate, and they did a report, and their report included criminal indictments against something like 10 federal employees and employees of Rockwell, who was managing the site. And that report never saw the light of day. The judge suppressed it. So, but what did some of the jurors do? They leaked, became national news. They leaked part of the reports to the press. So, I always say, when there's a will, there's a way. And, if you're on the Kenai grand juror and you're seeing some things that really upset you, you have all the right to do a report. There's nothing in the rules that stop you from doing a report. You can do a 50-page report, you can do a 200-page report. The issue is, how does that report get released to the public? And what happens if the Supreme Court judges? Now, I'm hoping that we can put a ton of political pressure on the Alaska court system here in the coming year. I mean, we all seen what Chief Justice Winfrey, he kind of cracked under the pressure when he gave that address to the legislature. And Chandra, I think I still haven't looked at that video. I was hoping I'd get time today to look at that, but I still haven't had time to open it. But there's a lot of us, and our numbers are growing in the state. Citizens who want to see these grand jury investigations go forward and report it. And we need to keep, the sit-in to show support to the people. It needs to be peaceful. It needs to be lawful. But to let grand jurors know that, hey, we care. I mean, David, what you just said about 500 people signing a petition, and they still wouldn't allow that to be considered by the grand jury, that is so egregious. There's no requirement that you need 500 signatures. All it takes is one person. But you went ahead and you got 500 signatures. What that tells me is how egregious it is. And yes, there has to be some repercussions for this, whether it's criminal prosecution, whatever. They have this is interfering with justice. And there's got to be some ramifications for that. So anyway.
Now, can I jump in one more time here?
Sure.
Sorry to kind of dominate things here, but the books that I gave them, your book, I put about half a dozen pages. I told them that they had to read, and I highlighted everything. So they don't have to go through 100. I'm like, go here, 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 and here. And, I'll have you know that with the Supreme Court thing, Clint Campion, the independent prosecutor, said the grand jury instructed him to look into the grand jury's ability to subpoena all 5 Supreme Court justices, swear them under oath, and ask them about how 1993 was possibly legal and constitutional. So, I mean, that's where this grand jury is going.
Wow. Yeah, that's awesome. So Campion actually told you this?
Yes.
You believe him?
Well, he's given me, I don't know who's on here. I won't say a bunch, but we all know why I don't necessarily trust Clint Campion, right? I mean, we all kind of know that.
Yeah.
But he has done things that there is no possible way he would do them if he was all bad. So there's some level of him that is doing the right thing. And there's no doubt about that.
Yeah.
And
well,
so,
David, just don't call, you referred to him as independent counsel, and he's clearly not independent. He's got a conflict of interest. So, I don't, just from a leverage stand, I wouldn't refer to him as an independent counsel. He's the attorney, and maybe he'll do everybody right. The proof will be in the pudding. I always have a saying, when I was trading loans, I said the deal was never done until the money was in my pocket. And I know that there's a lot of, people will say a lot of things to get you moving in one direction and thinking that, yeah, this is all good. And then bam, they hit you and you're left. So I'll believe it when I see it. When I see a report, I mean, I hope you're right, David. I hope that Clint Campion is telling you the truth, and that would be awesome if the grand jurors subpoenaed these 5 Supreme Court judges, because they've got a lot of explaining to do. I mean, this was another great thing about Thomas Garber's, appeal, because he got the documents. There was concerns by people on the Rules Committee about the constitutionality of Supreme Court Order 1993, and they railroaded it through. I would love to see those judges subpoenaed. And hopefully we'll read about it someday. Again, they may subpoena them, they may write up the report, and then that report may never see the light of day. But believe me, I'm doing whatever I can to see that reports like that see the light of day. And I know that all you, especially you, David, I mean, you've brought this thing along a long ways. And kudos to you for being consistent. And I wouldn't have written my book without your efforts, David, to have a grand jury investigation of this stuff. And so, and all the support, the 500 people who signed your petition, the pickets that you guys have done, everybody's sitting in the room. I mean, we've been going at this 12 or 13 weeks, and you guys braved the snow and the cold, and so yeah, this is very powerful, and I hope Campion is being truthful and honest. I mean, he really shouldn't be disclosing that information, which kind of makes me, because grand juries are supposed to operate in secret. So why is he telling you that? The whole thing is just kind of bizarre, but I do hope.
Yeah, I will just throw this in there, is I believe, this is my true belief, is early on, he may have tried to do the wrong thing, but I think the grand jury, he wasn't there at the beginning with the grand jury. There was a different, Jenna Grunstein was there. And I think the grand jury got some momentum, and he all of a sudden decided that rather than try to stop that momentum and maybe get run over himself, he would allow them to move forward. And this one thing I can say, because it doesn't directly, I try not to say exactly what I have personally seen about the grand jury, because I don't know if I'm supposed to do that, and I have done that, but he asked for evidence, asked for copies of that Supreme Court memorandum where it shows that they were bypassing. He asked for all that. I emailed it to him, and he emailed back and says, I hereby acknowledge as the Kenai Grand Jury's independent prosecutor, I acknowledge receipt of all these. If he was corrupt, he would not do that, because now if we ever find out the grand jury never got those documents, his goose is cooked. So you understand that that's some of the reason why I believe he's doing the right thing.
Yeah, I'm just very wary of somebody who, advised worked for the state, has a lot of colleagues there. You just got to watch it. That's all I'm going to say.
Well, in line with this topic, speaking of conflict of interest, you were reading about and talking about the right to a competent defense or an attorney.
Yes.
That we have that right. And I just, our own efforts with AFCR, and I know that many others have the same difficulty in our state, particularly, I think, to get an attorney that is competent or good, they've almost all been hired by the people that we would want to, that we need to defend ourselves against. So you go to hire an attorney in our state, which you have to have an attorney that practices and is licensed or, through the bar here, however that works. You know what I mean, though, that they have to be licensed in the state of Alaska to defend you or represent you here. And so we go to get an attorney that would even consider taking on the issues that we're, interested in pursuing. And they've all been hired. They've all worked for the governor. They've all worked for the state. They've all worked for the people that we need defense from. And you can't get an attorney in the state of Alaska that'll go up against them.
Well, that's an excellent point, Chandra. I mean, it's really a different issue from what I was talking about with indigent people in prison who or people accused who don't have any money and can't hire their own attorneys, so they're forced to either take the public defender, or a game that's played is the public defender will often conflict out because they represent one of the witnesses or somebody like that. So the case then gets transferred to a contract attorney who is retained by the Office of Public Advocacy. And these contract attorneys usually work for about 15% of the going market rate. And, they're like what we used to call mills. They're just churning a lot of paper, and, they don't really, this is why phone calls don't get returned. And, and this is a major problem. But I'm glad you brought this up, Chandra, because you bring up an excellent point. So people who may have the money to hire an attorney, but can't get one because the good ones are conflicted out. And yeah, good attorneys don't want to take on the Alaska Bar Association. They don't want to take on the system. They don't want to take on the judges. They know that they'll get blacklisted. I've had attorneys in Juneau here tell me that they fear for their own careers and they fear for their clients if they bring this stuff up. So it's a real issue. So what I would recommend is that you bring this up to your congressman or, your legislators, to let them know that, maybe we've got to look at maybe attorneys ought to be able to come in from outside the state. What about introducing some legislation that would allow people like you to go bring in attorneys from California? Or, it's basically, what they used to call a good old boy network. And, obviously there's a lot of ladies that are attorneys now and judges, but, it's the same kind of thing. It's a closed system. And this is one of the things that makes me want to pull my hair out, is that you have an attorney general that won't follow his own ethical obligations. And if an attorney general won't follow the rules of professional conduct, what does that say about every other attorney? But they get away with it because nobody calls them out on it. We have a legal system that's completely dominated by the Alaska Bar Association. They select our judges, and it's just, this is why Winfrey was so uptight the other day, because someone has the gall to challenge him. These people live in a world. They live in their own little bubble. They live in a world where no one challenges them.
Yeah.
They're brown-nosed every day of their lives. Not every day of their lives, but every day of their professional career. They get to the top, and who would dare challenge the Chief Justice of the Alaska Supreme Court? Well, you know who did? Mike Shower in his bill.
Yeah.
He called him out on it. Good for Mike.
He's been doing that for years.
This is what we need to bring this issue to the forefront. So this bill, and I'll talk more about it next week. I guess next week will be our last chapter 14, and that was the only time in the book I wrote the whole chapter and didn't quote anybody else. Those are my words, but that'll be probably a good time to talk about this SB 31, which is the bill that Mike Schauer introduced. And right now it's pending before the State Affairs Committee, which I think I want to bring up because Jesse Bjorkman, your new senator, is on that committee. And so hopefully, and this bill is a really good thing. There was public testimony on it on Thursday, and they ran out of time. So a lot of people who were waiting online to testify didn't get a chance. But the three people who did testify, one of them was Lauren Lehman, former lieutenant governor. And he said the same thing that he said during the CONCON debate, which was that a Democrat legislator, a leader in the Democrat Party, admitted to him or told him back 30 years ago that the Democrats will always control the way we select our judges. He said that in public testimony. So now that committee has to deal with it. And also on that committee is Senator Clayman. Some of you have probably heard about him. He's the chair of the Senate Judiciary Committee. And he's also, I think he's the vice chair of the Senate State Affairs Committee. He's a past president of the Alaska Bar Association. He was also on the Alaska Board of Governors for the Bar Association. He's a practicing attorney. So these are the things that Mike Schauer's bill are bringing to the forefront. And I think all of you in Kenai would be very well served to start bombarding Senator Bjorkman's office with the kind of issues we're talking about here, about judicial reform, and Chandra, what you just brought up, because it's a very real concern. So maybe we need to start opening up, because that's what I want. I mean, I want to make an amendment to this bill that provides for that takes grand juries outside of the domain of superior courts. Move them away from that.
Yes.
And fund them with money to have special counsel, independent counsel, and it's got to be attorneys from outside of the state.
Yeah.
I mean, it just
talk
has
about
to
a conflict
be
of interest.
The Alaska Bar Association has way too much power, and no one wants, for the very reason that you just said, Chandra. That's why we need to have independent prosecutors. This is what happened in the Sheffield investigation. We already have precedent for it. They brought in not Peter Frampton, but George Frampton. Peter Frampton, Show Me the Way, 1978. Frampton Comes Alive, one of my favorite albums back in the day. But George Frampton, Watergate veteran, was brought up from Washington, D.C. to advise the Juneau grand jury. And that's what we need in these investigations, are special counsel from high-powered firms outside of the state of Alaska that are beyond the political reach of the state government.
Well, I am going to wind things up, if that's okay with you. Lori, I'm gonna just a second, just hold on for a second. For those of you there in the room at Anchor Point, if you just want to end your side of things, what I'm going to do is I'm going to end the live portion on Facebook. And then Lori, I'm going to leave the meeting. I have to get going, but I'm going to leave it open so that you can ask your question of David. Will that work for you?
That's fine, and it's a follow-up on where you were.
Okay, but you can continue, David, and I'll just leave this. What'll happen is I will make David Ingell the host, and then he can end things when he's ready. Okay, is that all right with you, Mr. Ingell?
Yeah. Do I just need to press a button? Because
you just press the end button, and that'll end it for everyone when you're finished. Okay, so I'm going to go ahead and end things on Facebook. I want to thank everybody for coming tonight, of course, especially Mr. Ingell, and then also Mr. Haig for your comments before. Good night there in Anchor Point. Thank you, guys.
Good night, Chandra.
And just a quick reminder for everybody, March 15th is the sit-in particularly the Kenai courthouse if you can get there, but then your local courthouse if you can't, and to keep it peaceful and respectful, please, and to support our grand juries. And then you can go, we need donations. We to continue what we're doing, we need donations. We're all volunteers. So AFCR1776.com or the Alaska Grand Jurors Association.org for those. Thank you very much. I'm going to end the live stream.
All right, you guys, thank you guys all for being here today. Wow, boy, okay, I see what happened on my end. It's just a funny looking screen. Not used to seeing this one pop up on my looking like that. I had everything shifted around. Thank you guys all for being here today. Hopefully you have liked and shared this video. As always, you can find this on Twitter, YouTube, Facebook, and our website Politadick at politadick.com. All of these are at Politadick. In the next few hours you'll find this also at rumble.com/Politadick. If you're not a subscriber to Rumble yet, please become a subscriber. If for nothing else, just to like and subscribe to our page. We are trying to reach as many subscribers as we can over there. Our goal is to live stream directly to them, so you don't have to sit there and wait. And one more channel that we can guarantee a live stream to that will be uncut and uncensored in the end, in case there's something controversial that we know that Facebook and YouTube would ban and get us kicked off their platforms. They would look for everything like that. And there's a lot of stuff we've missed out on because we didn't have channels we could stream to uncut and unfiltered. And we're working hard to solve that. Of course, anytime we're live, you can always find us at politadick.com at our Politadick Live. Right now, if you were to go to our website, you would find us live on our page. You'd find us even on the home page over in the corner there. It'll pop up. And if you're looking on a browser, say on your cell phone, that is, and you scroll on down towards the bottom, your live link would pop right on up for you, showing that we are live, or you can always click on it if you know we are. If you're at our website, please go to our support page. All your donations go right back into expanding everything that we do. We have the next step in our evolution of upgrades that we are looking to do. We're looking to upgrade to a new monitor, and you can find a picture of that monitor in yesterday's broadcast. I think it was yesterday, actually it was 2 days ago's broadcast. There for the Palmer City Council, the Sedition and Porn and Unceded Lands, the Revisionist Histories of the Palmer's Museum. It was a very interesting community council meeting there. The community council basically, the resolution that came out of everything that was there was just extremely disappointing. It's going to be put on the top shelf in the adult section, was the response we were all given to what was discovered there. I mean, amazing what you can find when you go to the library. I never knew porn was available to be able to be checked out anytime you wanted. But there it is. Anyways, please again, like, share this video, go to our website, politadick.com, help support us, expand what we're doing. And also there on that video that I was trying to mention there is a link to the monitor that we're looking to get. It's a little pricey. It's about middle of the road for the monitors that are out there. But as you saw with tonight's live stream, and for those who are paying attention or may have noticed, that we were able to switch a lot of different screens today. We were able to take that zoom and actually capture different sections of the zoom and bring those people right on up front, so it was like you were talking directly to David Ingell tonight, instead of having to look at the three-paneled screen that was actually there and have to look at everybody else that was in the room. And then I was switching it up and adding in different types of panels there, bringing in different groups in the back, forward, and Ingell a little bit off to the side, and then all of them back in together again. And this has all been because of your guys' support that all of this has been possible, and a lot of head banging on my end, learning how to be able to make this stuff on the fly, and I'm getting very good at it, as you can tell. And as I keep going, it's going to keep on expanding, especially when I get all these little buttons on the Elgato controller down below completely programmed. and all the settings within the computer set to be able to do this, to where it'll be just touch a button and away it goes. The screen is changed. You guys get to see the magic and wonders of video making at an effortless press of a button. But you wouldn't believe the hard work it takes to be able to learn how to do that, and the time. Speaking of time, it takes a lot of time to be able to make it to these meetings, to make it to where their events are going on. They have one that is especially important to us here, those at the Alaskans for Constitutional Rights, or AFRC, that is short for Alaska for Constitutional Rights, 1776. That is AFRC1776.com. They need your support too. They are the ones that are helping to impanel and get these Alaska grand juries working back for Alaskans the way they were meant to be. Take the control that the judicial branch has usurped away from us Alaskans and said that they have, but constitutionally, legally, they have no right to do what they have done, and it's up to us Alaskans to stand strong. And the way we're going to be able to show an effort for that is going to be on March 15th. The big crowd showing, I guaranteed, is going to be at the Kenai courthouse, but they are requesting, if you can't be in Kenai but you have a courthouse that is more local to you, on March 15th, find some of your closest friends. All it takes is just one more person, maybe two, you know, and not to mention mentioning all the time to your friends out there. It might inspire others to help come join in the adventure, and show up at the courthouses throughout all of Alaska at 8 a.m. on March 15th, and sit on down and let's have a conversation with these courthouses and let them know that we want our Alaska grand juries impaneled. We want them to start investigations. And there is lots of different investigations that we could have them being and doing. One of them would be, a good example is the OCS and what they got going on. They made good mention of that here tonight during their presentation of David Ingell's books, Alaska Grand Juries, and the investigations involved in what he's discovered. Next week will be the last chapter, chapter 14 out of his book. And but this is the type of stuff that we need to get investigated. There's also other things like, you know, how did our Alaska Permanent Fund become in the control of Alaska legislators? How did the Alaska courts be the sole determinator that's saying that you shall pay something now means you may pay it if you feel like it, if you want to. But you know, that's what our judicial branch did to all of us Alaskans, which has given us our last 8 years battle down there in Juneau. And this is no exception to it this year. In fact, they're trying to steal another $750 million, or another $1,500 out of each and every one of us Alaskans' pockets from our permanent fund dividends, so that they can fund government. And one of those programs that they want to fund is defined benefits, which just got a brand new bill introduced in Senate Bill 88 for that is their defined benefits one that they're introducing. And then you got the House Bill 22, that is the House's version of the defined benefits. Both of them state within those bills that if the pension programs that these organizations are paying into our government employees, their union, so to speak, are unable to reach the achieved goals, it is up to the state of Alaska to make up the lost revenue back to their pension programs. So in other words, each and every one of us Alaskan taxpayers, the taxes that get paid, whether they like it or not, all gets pooled into one general fund, as long as it's not local, that is. And it all goes directly into that general fund to be redistributed, where else? Right back into the pockets of those government workers, because in 2006, the reason why we got rid of defined benefits is it ran us nearly $20 billion in debt on a state level. We're still $400 million in the hole here in the Matsu Valley trying to catch up that old pension program. It's going to take at least another 10 more years to be solidified and even again under the current program. And now they want to bring those defined benefits right back into the Stone Ages, clear back to 2006. when it drove our state into utter oblivion debt that was nearly impossible to get out from underneath. In fact, a good chunk of the CBR that they dwindled away extremely rapidly, I know of about over $5 billion that was given before Walker took office, that was taken out of that CBR account and was put into the defined benefits program to pay it down. And it has, that CBR has done a good chunk of the money coming out of that over the last 8 years has been used to pay that down. Whether you look at it or not, they may not have been came in directly out of the CBR anymore because they dwindled that away within the first couple of years. Now they take it from our permanent fund and they've been paying down those debts that they created. On top of that, you got to add in the Senate's bills and the House education bills for increasing the rate that the teachers are to get paid, the base student allocation formula. The ones that in the Senate claim is $1,000 and the one in the House that claims it's only $1,250. But when you get done doing all the magic of their new math that they have now within our school systems, in the Senate that number magically jumps to $2,000 per student, and in the House that jumps to $2,500 per student. Grand totals between the Senate is $270 million, and in the House that's $321.5 million. The defined benefits program was an additional another $221 million a year right there. So now you can already see where I've already got over $500 million there, that $750 million increase that we know is coming if they are able to pass just 3 different bills. The last one I'm going to mention is called RIP, R-I-P. I think it's Senate Bill 14. Don't quote me on that. I've only heard the bill once. I was the only person to give testimony the day they opened it up for testimony. And it's just another defined benefits bill that gives defined benefits to every government employee, kind of like the Senate Bill 88's version that they have there for their defined benefits. I gave you the House's cost for that. I haven't seen what the cost projection from the Senate is. Let's also add, this does none of their projections in the House for their HB 22 defined benefits. Nowhere in their financials that they've disclosed shows what it's going to cost on a municipality and a borough level for the contributions of what they're going to have to take from our local taxes, from our property taxes that we pay here locally, or maybe you got a sales tax in the town that you live, that's going to have to cover those defined benefit portions of the state's increase that falls onto the shoulders of the municipalities and the boroughs. Like I stated earlier, we're already $400 million in the hole still from the past program, just here in the Mat-Su Valley. We are sitting somewhere around $4 to $7 billion in the hole overall, depending on how the market is doing for the investment program that they have for their current benefit packages that they do have, their retirement packages, that is. If the market crashes down, they're about $7 billion in the hole. If the market stays about where it is right now, they're only about $4 billion in the hole that they still have to come up with to be at least hitting a negative zero value or a positive zero value, depends on how you count zero, breaking even. When will they ever get positive? Well, if they pass the defined benefit packages that they're talking about in the Senate, that'll never happen. We could have the permanent fund dividend completely wiped out. They would then have to increase the POMV draw above 5% right now that it already is, and they would be closer to around 6 to 7% they would be having to pull out of the permanent fund account every single year just to cover the shortfalls of the packages that they want to give away. I mean, it even gives for full benefit retirements at the age of 50. People are living to 80 to 100 years now. 30 years paying retirement? Come on, we cannot do this, Alaskans. We really got to wake up. Now we got education. Education wants all of this BSA money. I already gave the numbers, $270 million in the Senate, $321 million in the House. That's per year increase onto what they're already getting, which is currently right around $1.35 billion. That's just the state contribution. That's not what we pay on a municipality or a borough level. That always adds, and I think it's about another 25% more of whatever the state gives to that district is what's got to be matched by the borough or the municipality of the area that they're within. So that increases our property taxes, because if they increase their share, we've got to increase our share to match it. Now, there is zero, I mean absolutely zero accountability for any of the increases in the money. So if they continue to be a failure, the worst in the nation, 50th in the nation currently right now that they are, if they continue to do that, what they're doing right now, they're going to get an entire whopping increase of somewhere around $1.6, $1.7 billion from the state to go and spend willy-nilly any way that they want. They claim that they have not received a increase in the BSA formula since 2010. Let me correct the record here. We have had a population drop of somewhere between 10 to 15,000 students less going to school now than there was back in 2010. The BSA formula, the dollar amount that they have been getting, has been increasing with inflation every single year since then. Now, they have not dropped one single student base price off of what they've been receiving. So even though they're servicing 15,000 less students, they're still getting paid as if those 15,000 students are there in school. That's where that funny math comes from, you know. Somehow we have, 130,000, 128,000 school-age kids here in Alaska, but we're funding for 260,000 kids. When you can figure out how that math works, how we magically duplicate our children to where there's 2 of them out there, but that would explain a lot of things of why our education works the way it does. There are children when they're here, and the duplicate child that we're sending to school is now their child, and their child to raise the way they want to, which explains a lot if you're really into the tinfoil hat woke agenda that's out there. That makes perfect sense. You can be 2 people just like that. Well, it seems our school board and our school districts and the administrations, the NEA of Alaska, and our own Alaska legislators and governor and everybody else all seems to agree that 2 people is what's going to school. 260,000 kids going to school in Alaska, but there's only 128,000 listed on the census that we just had. Plus, that's also the records coming directly out of the school districts out there. That's how many they have enrolled in all the schools. Now, how many of those 128,000 kids are actually going to school? Well, we've got about an 84% attendance record throughout the entire state. So 16% of those 128,000 kids don't even go to class. They don't even show up. So 16% of the children there are completely gone. Out of 128,000 kids, that is roughly, 16%. 10% would be, what is that? So we got about 15,000 kids that are, 18,000 kids somewhere in there that are not going to school. I'd say closer to 18,000 kids that are not going to school every single day. But they're still getting paid as if their butts are there in the chair. So they're already getting paid for the 15,000 kids that are no longer live in our state, that no longer even go to school, but they're still getting paid for those missing kids. They're getting paid for the approximately 1,000 kids out of the 128,000 that don't even show up to school at all every single year. And then we've got somewhere around a 30, and it depends on what you're looking at for reading or writing and arithmetic when the scorings are out there. We're talking between 20 and less than 50% for all 3 of them. I mean, the lowest one starts out right near around 20%. The highest one that they're scoring on a district level throughout the state is still less than 50% of the kids. But we've got around 60% of Alaskan kids, actually more than that, it's closer to 70% of all Alaskan kids that can't even enter into college without having to take remedial courses that they get for free all 12 years of their lives in school. I mean, it's just, it's all 12 grades. It's just amazing how well and unfortunate our system works. So now we're funding the universities to provide an education that we've already funded our K through 12 to pay for to get, to provide an education to children that are taking the next latest and greatest gender studies, or let's review these revisionist history book classes so that we can go out into the world and get a job at Starbucks and having their little community meetings like the Queen's Guard every Friday night here in Wasilla at the Starbucks there, or every Friday during the day. And it's for the teens out here to go and meet, just so you're aware, if you weren't aware of that. But anyways, I think I've really digressed and gone off, but there is so much wrong in our state. And the accountability for the unions, I mean, all of the stuff that I've talked about here is all stuff that we could be paneling grand juries to be investigating. Why do we have the worst education in the United States? We can impanel a grand jury to investigate our school systems and the curriculums that they're teaching and what is going on within the classrooms. And why is it that most of the schools, 40 to, depending on which school you look at, it's between 40 to 70% of the teachers, depending on which school you're in, are not teaching the curriculum that is currently been established to be teaching in school. Now, the schools that are actually teaching the curriculum, the ones that are over the 50% mark, ironically are the only ones that are performing within our state when it comes to the score levels on the 3 proficiencies of reading, writing, and arithmetic. The ones that are scoring really low, that don't get the idea that you're supposed to go with the program, not create your own program, is a failure. And if you go to those classrooms and if you were to actually walk into the ones that are this way, you will probably find a rainbow flag flying in the room, maybe a poster with a fist on it going like this, you know, stand in unity, solidarity. You're going to find probably pronouns stuck somewhere within the room. Probably even one of those forms to fill out. It's identifying yourself as something else when you're within the classroom. But as soon as you walk out of the classroom and you're in a public place that, say, your parents might be in, you're now using your real name and your real biological sex. But when you're in the classroom, you got a safe space. Teacher will keep your secrecy. The principals will keep your secrecy, whatever you want to do. That's Anchorage. I mean, I'm explaining a lot of this stuff here, and I probably shouldn't, but I've been really missing being able to just sit in front of a camera and talk for a little while, and I'm full of a lot of energy. I've drank a lot of coffee today. Been turning a lot of wrenches, busting my butt. I'm finding that I'm working 2 to 3 times as hard as I used to, but I am not making the money that I was making when I was doing 3 times less work. Isn't that ironic? I'm having to work 3 times as hard as I used to, and I'm making 3 times less than I was before. So I'm just barely breaking even is the way things are working out. And it's difficult. I know many of you guys out there are having the same problem as me. You've cut out stuff that you used to do. Dinners out no longer exist like they used to be under Trump. You used to be able to go out all the time. You were able to go and do things. You could afford to go down the street and just go hang out. You can't do that anymore. The gas just to get there to go hang out is just not available. You can't go and have a lunch with a friend a couple times a week because you just don't have that extra money anymore. It's gone into your survival. And this is all in my book, The Tinfoil Hat Breaking Out, pre-planned and destined to be put into place, because if you have a populace that can't afford to protest, you have a populace that is not going to be able to stop the agenda. Why was Trump so successful? We all had money in our pockets. We were all out there every single day. We were in the face of our government, the officials out there, the people in charge. We were letting them know how we felt. We could afford to be there. Now we can't afford to. The people that actually work for a living that keep this country running, we're too busy just trying to keep a roof over our heads. If we're not going to do something to change that, and this is what this was all about tonight, this is what it's been for the last 14, 15 weeks they've been doing this. I'm trying to restream their broadcast for Alaskans for constitutional rights. This is why the Alaska grand juries are so important here in Alaska, to start doing something with them, why we need to get their powers returned to them, why we need to start making sure they are investigating. The grand jury is being impaneled to investigate the grievances we Alaskans have. And right now it starts directly within our own judicial branch. It is so corrupt, it's unreal. They brought up Senate Bill 31, which is Senator Shower's bill that has been working through legislation now, I think, for the last 4 years, that this would make number 5. For changing the way we choose our judges, and it handles 3 branches of the judicial out of the 5 branches of the judicial branch, or the 5 levels. You got the Supreme Court, the Magistrate, and the Superior Court, and those 3 can be put underneath the control of a completely different way of choosing those judges. The other 2 are protected under the Constitution, unfortunately, and they are stuck, but they're a lot more easier to get control of those picks than it is for the top 3. Those top 3 are held by the judicial branch and the Supreme Court, one Supreme Court judge that does the final pick. So you got 3 and 1, and then you've got 3 that are not a part of the judicial branch that are a part of the panel. Well, you can guess who the 4 are going to choose every single time, and our judicial branch shows that every single year. All right, I am going to get off of my soapbox. Like I said, I'm wound up. I could keep going, and I really could. But I do thank you guys all for being here tonight. If you have not gone and shown your support for what we do, please take a moment, go to our website, Politadick.com, click that support button. I know on the description of the broadcast that's here, the link is always there to be able to go and click on, make life really easy, or make it easy to remember how to type it in. And go to Rumble. Go to rumble.com. Subscribe to us there. I believe we have enough followers there now, and I've really got to get on that, and I'm hoping to find some time. Last couple of announcements. We've got this Sunday at the UAA of Alaska between 2 o'clock and 4 o'clock. And I will do my best to get a link up to it tomorrow. We've got a town hall going on with the Anchorage and Eagle River legislators that go to Juneau. So the Anchorage and Eagle River legislators, Senate and House representatives out there, will be at UAA between 2 and 4 o'clock on this Saturday, and that is March 5th, Saturday, 2 to 4, UAA. I will post the information for that tomorrow on my Politadick page on Facebook, and please show up. I don't care where you live. You can be in the Mat-Su Valley, you could be in Eagle River, you could be in Anchorage, you could be in Girdwood, you could be in Fairbanks, you could be flying in from Juneau. They are. I don't care where you are from, but we need to get in front of these Anchorage legislators and let them know how we Alaskans feel. This is our one and only opportunity that I'm pretty sure we're going to have before they determine what the budget's going to be, and these god-awful, oh my God, I can't believe they're putting them through the system bills that's going to increase the budget astronomically with no way to pay for it. It's going to be our last chance to get in front of them and confront them on it. And you guys are really good about getting in the faces of the Republicans, the Mat-Su 9, that they like to call themselves, you know, the Mat-Su 9, the 9 legislators that represent us out here in kind of Eagle River. Those legislators are not planning on having a town hall at all this year, just so that you're aware. That's why this one for the Anchorage legislators are so important to be to. And they are breaking it up from what I saw of the latest post on this town hall event, that those that live in Anchorage will get to ask their questions between 2 and 3, and between 3 and 4, it'll be the opportunity for those that live in Eagle River to ask their questions or have their 3 minutes in the limelight in front of the legislators there. And so I see it as a really good event to be at. I am working my magic to try to be there myself, to do nothing else other than live stream the event. I would love to be able to take a moment and talk, but I don't know if I'm going to get an opportunity to say anything in front of those legislators. But I'm inviting everybody, please show up. If you are one of those that loves your PFD, shows up. If you're one of those that is tired of watching our money being ripped out of our pockets to pay for an indoctrination, not an education, show up. If you're tired of them ripping money out of our pockets so that the special interests can live high on the hog when they retire, and I mean literally high on the hog. I mean, how would you like to be able to have basically a full salary retirement for the next 30 to 50 years of your life because of how long we live, and it's all being paid out of other people's tax money they take from us? You know, the ones that don't have retirement packages with the government to have it re-given back to us. We need to stand up and fight these agendas that they got going on, and if we don't, we're screwed. All right, thank you guys all for being here tonight. I really do appreciate it. If you've hung out this long, you are rock stars. Greatly appreciate it. Send yourself stars. Send me some love. Send yourself some love right now on this video. Hit that heart. You guys have all been greatly appreciated. Have a great night, and we will see you the next time. And thank you all once again for being here. Greatly appreciate it.